Hello, my name is Daniel Valverde. I am the partner of the Employment Law and Human Rights Practices of ESIHA Costa Rica, as well as the Chief Diversity Officer of the firm. Today, I will discuss with you the right to disconnect as a human rights issue. If you are working from home, you probably started working much earlier today than before, and you will probably call it a day only when your pet starts whining for dinner. Should that be okay? Should we do more to avoid working beyond our established workdays? If you have those questions, welcome. In March 2020, many countries around the world authorized lockdowns to stem the spread of COVID-19, which brought the global economy to a standstill. As a response, many workplaces decided to apply work-from-home schemes almost immediately in order to keep businesses open and avoid a severe loss of jobs. Almost overnight, even the most reluctant employer or employee was now forced to apply teleworking. According to a recent article quoted by the US Bureau of Statistics, 31% of workers who were employed in early March had switched to working at home by the first weeks of April 2020. The spread of the internet and high-speed connections allowed such change to be possible in such a quick pace. For employees fortunate enough to work in an industry that can continue to do so remotely, it allowed them to not lose their income or jobs during the harsher lockdowns during the pandemic. However, as I myself has experienced during this situation, working from home blurs the lines between our working day and our personal time. No longer do you wake up to get ready to travel by car, bus, or train to the workplace. In teleworking, you start your workday by powering on your computer and connecting to the internet. And when you finish, when eventually you realize it's too late and you need to get dinner. Also, you probably have installed a mail app on your phone so you can check emails at any time. And you sure have received work-related calls or messages through a messaging app at night, on a Sunday, or even when you are in vacations. This side effect of the pandemic has caused us to work longer hours in detriment to our health. According to an ILO report in 2020 regarding teleworking during the pandemic, 1 in 4 employees say that they must work during their rest times to cope with additional work. According to a data analysis conducted by NordVPN, employees are working 3 more hours than before the pandemic began. This is without mentioning the struggle of employees that must care for children, elderly, or relatives with disabilities, while managing to work longer hours from home. Worse yet, during the challenges of supervising a teleworking workforce, most of this extra time is not considered for overtime pay. This trend has raised concerns about burnout effects that could affect employees, as well as our permanent connection to software work tools. As such, more and more voices are demanding more employment regulation for this matter, starting a discussion on whether we should recognize a right to disconnect from the workplace. Such right implies that employees have the right to disconnect from their devices when their workday ends, to deny phone calls or not answer messages or emails outside that time frame without any risk of retaliation, unless the employer duly compensates that as overtime. Can this digital disconnection right be considered as a minimum employment human rights standard? We face the issue that a grand scope of employment rights was not previously considered to be justiciable rights in the international protection system of human rights. Such consideration stemmed from the fact that most breaches to employment law come from private employers. Our international system revolves around obligations generated to states, not private individuals or corporations, meaning that, in a traditional sense, you could not claim to an international system or court a breach to employment rights caused by a private entity. Although currently you still cannot do such a thing, new case law has considered a breach to international obligations the fact that states do not supervise the compliance with minimum employment standards. For example, workers of the European Union are now granted certain minimum rights relating to health and safety at work, protection against discrimination of any kind, among others. Each of these rights must be legislated locally, and employment inspections should be put in place to oversee their fulfillment. If not, the non-compliant state could be held liable in the EU's protection mechanisms. In the Americas, employment protections are considered within the scope of Articles 16 and 26 of the American Convention. The Inter-American Court has reviewed several breaches of states regarding the protection of employees against termination for freely expressing their opinion, as in the case of Lagos del Campo against Peru, or more recently, the violation of the right to work in a safe environment in the case of employees in a fireworks factory against Brazil. So, it is more apparent than ever that though employment rights are for employers to comply, there is an international obligation for states to recognize them, but also to supervise that such rights are being complied. Now, does that include the right to digitally disconnect from the workplace? Given the international regulations of the right to a limited workday with the corresponding rests within the work shifts and the weekly rests, the answer to that would be a resounding yes. Digital disconnection should be part of the 21st century employment human rights. For its applications, states should consider: first, recognizing the right to digitally disconnect in local law. Although employment regulations probably have the limitations of the workday, it must be updated to deal with the use of software that allows us to be connected to our employment obligations 24/7. Second, retaliation against employees that enjoy this right should be expressly prohibited. Employees should not be subject to admonishment or termination because they did not render work outside of their workday. Third, states should oblige employers to have a registry of the hours worked by all employees. Such registry, for example, was mandated in the European Union to overview the overtime worked and not paid. Its broader application internationally should also be useful for teleworking employees, and it would be an excellent tool to determine the amount of time worked by work-from-home employees. And finally, fourth, digital disconnection and respect to workday limits is an employment human rights issue. As such, it should be overseen by states, and a lack of supervision can hold the state liable in international human rights instruments. Let us keep in mind that, although work is important, and in my case, one of my dearest passions, we cannot lose sight that the employees require time to be with our families and to pursue our hobbies. Thank you all for attending this lightning talk of RightsCon 2021. I hope that you found this subject insightful, and hopefully afterwards you will take a little break from your computer after seeing this. Farewell.